All right, good afternoon, everyone. Thank you for joining us today to discuss fair housing concerns for IROs. Before we get started, I'd like to thank our exclusive sponsor of today's webinar, Yardi. And we have James Hafen on the call today. He's General Manager of Industry Principal Inside Sales at Yardi, and he's here to tell you more about our sponsor. James?
Thank you very much. Happy to be here. Thanks for inviting me to speak on behalf of Yardi at the webinar. I've been working in the real estate space for the better part of going on 2 decades now, since the late 1990s. Primarily mostly in self-storage, but the last 4 years here at Yardi in multifamily concerns, and I'm just thrilled to be able to represent Yardi at NAA IRO events like this. Here at Yardi, we're very committed to supporting continuing education in the real estate industry. We really think that it benefits everybody involved, from owners, investors, managers, and even on-site staff. We think the IRO committee is an incredible asset to smaller operators, and together we've collaborated on several important initiatives, including developing new energy training curriculum and contributing to the NAAEI Now campaign. We also firmly believe in providing support and aid during times of need. We've had quite a year of natural disasters, and from contributions to local charities to nationally coordinated efforts to supply help and housing assistance during these natural disasters, everyone at Yardi goes the extra mile to make sure our clients and the communities we serve have all the help they need whenever and wherever catastrophe strikes. It's ironic. I'm actually in Salt Lake City, so I'm a little bit out of the line of fire, no pun intended, but most of our Santa Barbara office this week is actually under quite a bit of duress as those fires move up north through Santa Barbara County, and so we're all watching carefully to see what would happen there. But our real dedication to the real estate industry has been our unique focus for more than 3 decades now, and our goal has always been to create software that makes it more efficient and profitable for you to run your business, no matter what size your portfolio. And for the last several months, we've been previewing and preparing a refreshingly simple software product that we believe will change the way you think about property management software in general. On January 1st, we will formally launch Yardi Breeze. It's a software platform specifically designed for small to medium-sized owner-operators. From marketing to management to maintenance, Breeze is intuitive to use. It's very quick to set up. It's designed to work on any device, and even better, it's backed by Yardi's unmatched experience and reliable accounting. Yardi Breeze is a streamlined platform that's so simple to use it requires virtually no training. Comes with no implementation cost, includes expert support available on demand, and all of this at a price that I think everybody can afford, starting at just $1 a unit a month. We are super excited about the possibilities of this new product and how it's going to revolutionize the way everybody does business in this industry. If you're interested in learning more, my contact information is on the screen. You can also find us at yardibreeze.com for more information. We'd be happy to reach out, keep you in the loop, and give you a preview of this product that's coming in just a few short weeks. Anyway, thank you very much. Hope everybody enjoys the webinar. Thank you.
Thank you, James. And thanks again for your support for the IRO committee in 2017. We really appreciate your support and commitment to NAA's independent rental owners. Today's webinar is being recorded and will be available on NAA's website in the very near future. You'll need to visit www.naahq.org/AEX, then select the Independent Rental Owner category. If you have a question during the webinar, please type it in online at the right of your screen in the space where it asks for questions, and we'll read them aloud at the end of the webinar. So moving on to the presentation for today, a quick note about process. So today you have 4 experts at your disposal. Sorry, trying to advance the slides. All right, so you have 4 experts at your disposal. First, I want to give you a brief overview of the laws that are applicable to our key issues today. And then I will mention some of NAA Government Affairs, our resources that we've produced for you that are available to you. And then Lauren Kelly from the NAA Click and Lease team We'll talk about aspects of the lease that give lease users added protection. And then we will also have Mark Hurley and Kirk Cullimore on the line to give you a sense of how the law applies in real life. In Mark's case, in his business, and in Kirk's case, how he advises his owner-operator clients on these issues. And just an FYI, I think we're having some technical difficulties with Mark, so we'll have to keep you posted on his status. So one final note before we go into the presentations, I want you to remember this key takeaway. Whatever your policy is, make sure you're documenting everything. It will help you later on down the line from a fair housing perspective. If, for example, you documented why you approved or denied an emotional support animal request, or why you denied an applicant based on your stated screening criteria, this will make it clear the non-discriminatory reason why you came to your decision should you be challenged or sued later on down the line. So make sure your company has written policies related to these issues and a process by which you implement these policies at the site level. Remember, you want to apply each policy evenly amongst all individuals, whether that's by phone, via email, or in a face-to-face conversation. And remember, consistency is key. When you let resident A do something that you're penalizing resident B for, that's really what gets you into trouble with HUD or the local fair housing groups. So jumping right into emotional support animals. Again, these are our focus areas for today. So we'll focus on what you can and can't do under the Federal Fair Housing Act and take into account any applicable HUD guidance. So looking at our first issue, emotional support animals, there are applicable laws related to this. There are other applicable laws related to this issue. For example, the Americans with Disabilities Act may cover the leasing office or guests on the property, or there may be state or local fair housing laws that sort of overlay additional requirements on top of what we discuss here. But if you have any questions about that, I highly recommend you contact your local affiliate or seek the legal advice of local counsel. And that is our advice for this issue or any other issue that we covered today. So as a reminder, the Fair Housing Act covers 7 protected classes, and one of them is disability. One of the prohibited acts of discrimination under the Act related to disability is the refusal to make reasonable accommodations. A reasonable accommodation is a change in rules, policies, practices, or services, basically making an exception to these for a disabled person that is necessary to afford that person the equal opportunity to use and enjoy their dwelling. An example of this would be a reasonable accommodation request for a resident who needs an animal in a no pets building. Also, I should note the Act applies to all publicly owned and privately owned housing. There are a few very limited exceptions. That is, if you are operating a building with 4 or fewer units and one of the units is occupied by the owner, or if you're operating single-family homes that are sold or rented without the use of a broker. The Act also exempts housing operated by religious organizations and private clubs, but that's where the occupancy is limited to their members. So the Fair Housing Act covers requests for assistance animals. And what is an assistance animal? And we'd like you to think of it as an umbrella term that covers both service animals and emotional support animals. So this could be an animal that works, provides assistance, or performs tasks for the benefit of a person with a disability, and that's commonly referred to as a service animal. So that would be a seeing eye dog, a dog that is trained to alert the disabled person to an impending seizure or an impending asthma attack. Or an assistance animal could be an animal that provides emotional support that alleviates one or more identified symptoms or effects of that person's disability, and that's commonly referred to an emotional support animal. So I want to stress here that it is not required under the law that the animal be trained or certified. However, many service animals, as I said, are trained to perform a task, as I mentioned. You cannot deny solely on the basis that the animal is not trained or certified. So I just want to stress that. On the other side of the coin, if you have a resident that brings you a certified emotional support animal registration card or some sort of certificate, or they come to you with this animal that's wearing a special vest, those are definitely red flags that it's probably not a legitimate request, and you can ask for more information to be able to process that request. And so also an assistance animal, whether it's a service animal or an emotional support animal, it is not a pet. So never refer to an assistance animal as a pet. You know, residents aren't so familiar with the terms, and they might use additional terms like therapy animal and all that. But you know, let them use whatever they want, but just be sure that when you're deciding on whether to approve or deny the request, that you know what's covered under the law, that you know what an assistance animal is, a service animal, an emotional support animal, and how those are defined under the law. And just also remember, an assistance animal could be any animal. It could be a snake, it could be a rooster, it could be a goat. More likely than not, it's going to be a cat or a dog or a bird. And we'll talk about how to deny a specific animal later, but just remember they come in all forms. All right. So what do you need to know when you're deciding how to handle a request for an animal? You need to ask yourself two questions. First, does the person seeking to use and live with the animal, is that person disabled? And the law defines disabled or handicapped, as it is the term in the law, is defined as a physical or mental impairment that substantially, and I want to emphasize substantially, limits one or major life activities. That's the first question. The second question you should ask yourself is, does the person making the request have a disability-related need for the assistance animal? And you'll often hear the term nexus here, which basically means, does the person have a disability, and is there a link with that disability to their disability-related need for an assistance animal? So let's take, for example, a request from a resident. They catch a staff person doing a walkthrough on the property and say, I'm having mobility issues, I'm losing my eyesight, I'm going to need to get an animal to help me get around. And so, you know, just a reminder, requests can either come verbally or written. And so they've actually made the request and already started that process there. And they've also given you the link, the nexus, which is to say the person does have a disability and they do have a disability-related need for their animal. So in that case, that would be a case for approval right there. All right, so what else should you know? I want to stress a big no-no is do not ever ask them what their disability is. I take the classes that fair housing investigators take, and they provide the other investigators in the classes with an emotional distress checklist, which basically means if you're continuing to refer to their animal as a pet and you're saying things, which I hope you would never do, like, are you really disabled? What is your disability? Are you really disabled? They're going to use that. The investigator is going to see that as antagonizing the resident. That's basically like separate, distinct causes for emotional distress in their eyes, and they're going to use that as a way to increase the damage amount that they think you owe the resident for harm. Also remember that under the law, you're required to engage the resident in an interactive process. So never just say no. That's going to hurt you in the long run. If they complain to HUD or a local fair housing group, always try to engage them in the process. Let them, like take, for example, what I said about the person stopping the staff member on the property. This is a prime example of where you can engage them in the interactive process. They've verbally given their request, but then you can sort of follow up and say, let's schedule some time so I can walk you through the process. This is how we handle these requests for anyone on the property, and I can walk you through that. That's also a way for you to get all of the forms and documentation that you need necessary to process that request and get it into the file. All right, so next slide. So for this slide, I kind of want to break things down between the rights of the resident and your rights as the owner. So just to start, when you approve a request for an emotional support animal or service animal, that animal must be allowed to go wherever the person may go. So you cannot restrict access to the leasing office, the common areas, or the pool. But with that said, there are some local health codes that give you cover to restrict animals in somewhere like the community room where food is being prepared or in the actual pool. But remember, it also depends. There can also always be exceptions. One example is if you get a doctor's note and the doctor says, my patient, resident A, has seizures and needs this animal to go wherever they go to alert them of an impending seizure. So that would be a case where you would probably need to contact a local attorney to get more information on this, but you might not be covered if you're using a local health code by restricting access to that particular animal, but this will be a rare case. You also cannot apply breed, size, or weight. Excuse me. Weight restrictions to the animal. So let's say that you have breed restrictions for your apartment community and you don't allow pit bulls. You cannot deny that animal just because pit bulls are known to be dangerous. We'll go over specific denials later, but you can only deny based on the behavior of that specific animal or the conduct that you've observed. So you cannot apply these general breed, size, or weight restriction policies on an assistance animal. A resident is also allowed under the law to request multiple animals. With that said, you can take into account, for example, what are the separate and distinct reasons for each animal. For example, if you have a person, a veteran, for example, who requires a service dog for their mobility issues, but they also require an emotional support animal for emotional trauma. Those are two separate and distinct disability and disability-related needs for those animals, but again, probably a rare case. Also, you cannot apply conditions or restrictions on the request. Back to the pit bull scenario. You cannot apply conditions or restrictions on the request. That's to say you can't restrict, you cannot say, well, I'll allow you to have the pit bull, but you have to have liability insurance in case it bites someone. You cannot do that. You also cannot assess pet rent or pet fees on an assistance animal either. And as far as your rights go, so what are the rights of the owner? When can you ask for supporting documentation? You can only ask for supporting documentation when the disability or disability-related need are not apparent. So an example of something being apparent would be a seeing eye dog, where the person comes into the office, you've observed that they are visually impaired, they have a walking stick and are using the animal to help guide their way. You could not ask for supporting documentation in that case. On the other side of the coin, in most cases, an emotional support animal, with an emotional support animal, the disability or disability-related need would likely not be readily apparent, so you would be able to ask for supporting documentation. And next, who can write the note? Can you require a doctor's note? So you can only require third-party verification, as I said, when the disability or disability-related need is not readily apparent, and it does not have to be from a doctor. It could be from a doctor or any medical or mental health professional, a peer support group, a non-medical service agency like a social worker, or any reliable third party who is in a position to know about the individual's disability may provide the verification. And let's talk about denial. So when can you deny a reasonable accommodation request? According to HUD, the request may be denied if doing so would impose this is the first reason for denial, would impose an undue financial and administrative burden, or if would fundamentally alter the nature of the housing provider services. So I've seen this very rarely used in an emotional support animal case. This is typically a rationale in, let's say, an accommodation request by an elderly person who wants the apartment staff to help them carry their groceries or help them take out their trash. And that would be an example of fundamentally altering the nature of your services by allowing this behavior just for one resident. You'll likely be able to deny an animal based on these other two rationales, which is the specific assistance animal in question poses a direct threat to the health or safety of others, or the specific assistance animal would cause substantial physical damage to the property to the property. So in order to determine this, you need to have you need to do an individualized assessment on this particular animal. So you would need to have objective evidence that shows this particular animal's conduct. So just as a reminder, I don't know if I mentioned this, everything that I'm saying today is coming from the NAA Emotional Support Animal Toolkit. The toolkit also contains frequently asked questions, scripts to help you train staff, and it also includes sample assistance animal reasonable accommodation forms and policies, and those are there for you to use. And as part of the forms, it includes a request form, a sample animal ID form, and a sample verification form. So as part of these, you'll notice when you look at the forms that there's a place there where you could potentially ask them, was this animal involved in a situation where the police were called or animal control was called, or if you saw this animal in person exhibiting behavior such as snapping or biting or aggressive behavior towards you or anyone on the property, that could also be a rationale to deny for that specific animal's behavior. All right, and let's see, what else? Like I said, I just plugged the toolkit. Everything that I've said today comes from the toolkit. We also, on the Assistance Animal Resources page, have recordings of previous webinars and education session recordings where we do a deeper dive into issues like the internet forms that you might see, what to do if you require doggy DNA on your property, how do you handle if it's a lease violation and they're not picking up after their pet, or things like that. So I'd highly recommend you looking at the toolkit and also the Assistance Animal Resources page. And so with that, I wanted to turn things over to Lauren to kind of talk about what resources lease users have available in the Click and Lease program.
Sure. Thanks, Nicole. So as Nicole mentioned, you don't have the option to charge for deposits or fees when it comes to assistance animals, whether they are service animals or emotional support animals. So NAA has developed a separate assistance animal addendum. It's made as an amendment to the existing animal addendum. So if you use the Click and Lease program, the one form is used to supplement the information collected on the animal addendum, and then also specifies all the rules that Nicole just outlined, such as no fees and things like that. However, the rules of still looking after your pet do apply, that you can't bar them from certain areas, but they are meant to pick up after their pet. They are meant to have them act in a manner which is safe for the community. And we at NAA, especially our lease team here, plan to continue working with Nicole in Government Affairs and with Kirk, who I know has a lot to add on the subject, so that we can take our lease forms to make sure that they work in conjunction in the correct operational way with the NAA toolkit and with some other forms that Kirk has developed on his end. So I think that would be a good segue into what your experience with this, Kirk.
Well, I appreciate that. The key really on any assistance animal is just to be consistent on the way that you're handling it. As most of you know, you generally find out about an assistance animal because you catch them with one, not because they're coming forward with it to let you know. And you need to be consistent in reading the way that to handle that each of those situations, and making sure that you look at the doctor's notes to make sure that they're giving you sufficient information that you can actually verify in the information that you've been given that the person meets the definition under the Fair Housing Act of being handicapped, and that there is that nexus between the handicap and the need for the animal. As most of you know, this is an area that we worry about primarily with the emotional support animals. I don't think I've, the last 30 years of dealing with these issues, we've had any issues with true service animals. But the emotional support animal issue has become such a plague in the industry that we're trying to find ways to assist you and HUD and the truly disabled people to be able to get their animals when they have a true disability and need for them, and yet not have these additional costs of people that that may not meet the definition and are just attempting to get their animals in under the guise of being an assistance animal. And so as you evaluate each of these requests on an individualized basis, you need to be careful that you're looking at the information the doctor has given you, or the medical professional or the social worker, and as you review that information, make sure that it gives you sufficient information to determine that they meet the definition and the nexus. And if it doesn't, that's when you need to probe a little bit deeper to make sure that you can obtain that. As you look at the toolkit, it suggests that you accept any form from any medical professional that they give you, whether it's a prescription form, whether it's a letter or a note. The problem with those is generally they don't contain sufficient information for you to actually make a determination whether or not the tenant will meet the definition. And you're entitled to go a little bit further until you obtain that sufficient information by either calling the doctor or by letting the tenant know or the doctor know that the note's insufficient, that you're going to need additional information. And as you read through the toolkit, it gives you some guidance on how to do each of those things.
All right, thank you, Kirk. And I don't know if I mentioned this, but the forms that are in the toolkit are from Kirk Collmore. He's done extensive work on fair housing issues, and the forms and the sample policies came from him. They're there for you to use, but please do not alter them in any way. And, you know, as I said, please feel free to use anything that's in the toolkit. There are resources at your disposal. Mark, did you have anything to add?
Yes. Hi, Nicole. Can you hear me?
Yes, we can.
Okay, great. Thanks. So I won't cover any of what you've spoken about, you know, from a legal or regulatory perspective. Rather, as an owner, I'll talk about some of the things we've done that I believe help us in dealing with the emotional support and service animal issues. So one of the things that we've done is Starbucks, for example, has a sign up in all their coffee shops that say service animals are always welcome. And I think when somebody walks in and sees that sign there, it immediately puts people, takes people off the attack, maybe disarms them a little bit. So putting that signage up in all of our offices, saying that they're always welcome, defining what they are, and in that we sort of include the emotional support animals as part of the service animals, even though technically perhaps we define it differently. And we say why we welcome them as well. This also helps us, and we own everything from single family homes to apartment communities, but this also helps us with our own managers, because part of what we do with our own managers is we call around and we test them. And we don't let them know that it is us that are calling, and we ask them a series of questions to make sure they're not making any mistakes with regards to the replies they are giving to callers or applicants, because there are a lot of testers out there, and there are some rather large companies in Texas that have gotten into trouble because of an answer on the phone, you know, with regards, we will charge a deposit for this type of emotional support animal or service animal under these circumstances. So we test our managers, and it's good for them to have the answer behind them, which is, yes, service animals and emotional support animals are welcome. And I would recommend that if you have a few locations and a few managers, that you do run a test on them occasionally. The other thing that we try to do is we try to encourage all our staff to treat these situations on a one-to-one basis. And part of dealing with this, in order to be safe, although it may not seem reasonable, we're trying to protect ourselves by saying, think of this animal as someone's child, and don't judge them on how they look, or whether it's, for example, an aggressive breed. You could say, you can't judge the Viking child and say that it's going, I'm watching Vikings at the moment, and say that's going to be an aggressive child because they're a Viking. You know, rather we try to look at what the individual actions of that particular animal are, rather than classify the entire breed as aggressive, and hold the parents of that animal responsible rather than necessarily the animal itself, if you understand what I mean. And so long as, even if they are an aggressive breed, they don't harm the rights, comfort, health, safety, or convenience of our residents, guests, or staff members, you know, they should be fine. And if they do, we document it and we take the appropriate actions with regards whatever type of element might affect those rights, comforts, safety, etc. I think that helps keep us out of trouble. And on you know, the other thing, the last thing I would say to consider is, you know, in our company, in most of our properties, we don't even charge a pet deposit or pet rent. And I know that's unconventional and perhaps doesn't directly apply to this, but I wanted to share that with the IROs on the call, because it does give us, I believe, a little bit of an advantage with regards. It keeps our residents happy with us. We don't ever have to argue with them about pets. We don't ever run into emotional support animal or service animal problems. And it helps keep turnover lower and helps us with guest relations. It also gives us the opportunity to provide them amenity, because we tend to focus in their pets, and we get a large number of them, an ever-increasing number of them, into, you know, dog parks and being able to give them doggy bags, which makes them happy. It's sort of given us a bit of a niche. It also means that if they haven't paid a pet deposit and a pet fee, that there's a higher barrier to exit, because we tend to attract people with pets, and then those people, if they want to leave us, have to come up with a pet deposit. So I'd add that little tidbit in there as an unconventional way of approaching this. And with that, I'll let you guys move on. Thank you.
There was just one other thing that I wanted to add in general for reasonable accommodations. For any of you on the call that use the NAA Quick and Lease program, you would have received an email about this, but I just wanted to give you another heads up. We are now adding reasonable accommodation forms that have to do with any other circumstance than assistance animals, and they'll be available through our program, and that includes a policy, a request form, a verification form, and a separate approval or denial form. So those will be live on December 27th, and you'll be able to log in and see previews of those. If you have any questions about them specifically, I would say the first step would be to your council with your operational procedures, but if you ever need anyone here at NAA, we can also get you to the right folks as well. That was all I had on that one.
Great, thank you, Lauren. So moving on to our next topic, it is disparate impact, and that really covers everything else that we're going to talk about today, whether that's occupancy, familial status, eviction, screening, or criminal screening. And for those of you who are not totally up to speed on what disparate impact is, if you've ever faced a discrimination complaint from a resident, it is based on likely based on one of two legal theories, and that is disparate treatment and disparate impact. So disparate treatment is they're basically saying the plaintiff is alleging intentional discrimination, whether that's you deny them because they're a member of a protected class, or, which I would hope you would never do this, the case of a direct evidence case where you put on Craigslist no families, no children, or something to that effect. And that is different than disparate impact, which is a policy that is neutral on its face but has a disproportionate negative impact on members of a protected class under the Federal Fair Housing Act. And I said it applies to anything that we're talking about today because it is basically unintentional discrimination that could be applied to any policy. Not to scare you, but it really could. And if you think about it in terms of criminal screening, if you have a policy, a blanket policy that says no felons on the property, period, what HUD will say is that there is that African Americans and Hispanics are incarcerated at much higher rates than the general population. So even if you have a policy that's neutral on its face, a policy saying no felons period would have a disproportionate negative impact on minorities, and they are protected under the Fair Housing Act. So kind of applying that to familial status, this could be any policy that could apply, that could have a negative impact on families. So, you know, a couple examples. If you had a policy that said no toys on balconies, or another policy that said no children under 18 in the fitness center or at the pool unattended. And if you think about that second example, no children under 18 at the pool unattended, that is targeting families with children, which could get you in trouble. And also, what about the student athlete? Why can't they be in the pool area unattended when they're seemingly to be capable of handling themselves in that area alone? So what we recommend here, and these are also part of some NAA resources that we have available, we do have a white paper on occupancy and familial status, and we have another white paper on criminal screening, and those have both been reviewed by a prominent law firm here in town, here in the DC area, who've done extensive work on fair housing and litigated numerous cases against HUD. They reviewed the white papers and come up with some best practices that we'd like to share with you. So in regard to the two examples I gave you, you want to make sure that your rules and policies, remember that wording matters, and you want to try to use broad and inclusive language. And if you are going to have restrictions, make sure you state those justifications and document them. So let's take the no toys on balconies, for example. You might want to change that to say, for safety purposes, residents must keep balconies clear of obstructions. And then it's much more broad, and it's not targeting one group or another, just generally at the residents and their behavior. Or, for example, the no children under 18 in the fitness center or the pool. I did a webinar previously with another attorney, and she recommended this language. The pool has inherent risks and dangers. Any person unable to comprehend said risks and dangers should be supervised by a competent adult. So then the onus is not on you to come up with an arbitrary age. You are basically saying whether the kids are 14, 15, 9, if they don't understand the risks and dangers and they're running around the pool area and disturbing others and being loud, then they don't understand the risks and dangers and should be supervised by an adult. And so there could be a lease violation there that's not necessarily targeting the families on your property. All right, and then let's talk about occupancy standards. So we've kind of seen all over the country that fair housing groups are targeting owners who are relying on a strict 2 persons per bedroom occupancy standard. And for those of you who are familiar with the Keating memo, that is a memo from almost 2 or 3 decades ago, that says the 2 persons per bedroom standard is okay, according to HUD, but with limited exceptions. So you would need to make an exception for parents with a baby, or you might need to account for a den or another space that could be used as a bedroom. That might require you to increase the number of occupants that are allowed in that particular unit. And unfortunately, fair housing groups around the country, they are taking the Keating memo and using an expanded interpretation, which would require owners to consider local building code or local health or overcrowding codes that might say, you have to consider the full square footage of the unit, the full livable space of the unit. So that would, so we would suggest that you consider, as it shows here on the slide, the size and configuration of the unit, the age of the children, any state and local laws, or any physical limitation of the housing. So we wanted you to just be aware of that. Kirk, I didn't know if you had any thoughts on age-wise, if you're if we're telling people that you should consider sort of opening that up to a 2+1 standard, that would give you more cover with these local groups, what would you recommend with age?
Yeah, we've started recommending that we do a 2+1 to all of our clients. So a 2-bedroom unit would be 5 people, a 1-bedroom would be 3, to try and cover that small child or something else that might fit into the exception. The other things obviously are things that we do have to consider, particularly if it's not a typical apartment type community. If there's, the size, whether there's a den, whether there's in single-family homes, you have a lot of things that you need to be very careful about when you start putting occupancy standards in single-family homes. The big concern, obviously, that we've had is there's been some press by some local fair housing agencies that are trying to use things like fire code that says that that increases the number of occupants significantly. A fire code would allow 3 or 4 times the number of people in a single-family dwelling that we would consider to be reasonable occupancy standards in a rental type unit, and that's where we're seeing the big push right now, is in people looking at state and local codes that don't necessarily deal directly with the type of occupancy standards that a rental unit would deal with, and extrapolating those into the rental industry. And I think what we've talked about here is important, that we look at the size of the rental and the configuration of the unit, like you said, if there's a den and things like that. And then I do think that you need to have just like we've done in many other things, is allow for a potential exception to the rule for depending on the age of the children. When we talk about a 2+1 standard, we had cases where a young couple is in a 1-bedroom unit and they have a newborn baby. Well, most of us would agree that a 2+1 in that situation is great. But if they had newborn twins, now you're at 2+2. And so I think you have to be cautious that although you establish a standard, that you still have the same ability to review your own standards under special circumstances and situations, so that you don't take inappropriate action against somebody in a situation where you really aren't trying to stick to your firmly to the occupancy standards. Again, when you make exceptions to the rule of any of your occupancy standards or other rules and regulations, you want to document why you made an exception to the rule and why the situation is, and so you don't get stuck in that situation where somebody said, well, you made an exception for them and you didn't make an exception for me. You want to make sure you put enough detail in it that you're comparing apples with apples, and the more detail you put, the less likely that the comparisons will be similar.
Thanks, Kirk. Mark, did you have any thoughts?
On occupancy, not particularly. Sorry, go ahead. With regards the pools, we've been changing our pool signs from what we used to have, which did say before children should not use without adult supervision, which didn't tell them they couldn't, but rather that they shouldn't, to the sign that I saw when this was presented at NAA, which was the pool has inherent risks and dangers, which I think is the way to go.
Great, thank you, Mark.
Other than that, on occupancy, I would just say, one of the big strengths of IROs is that we don't have 20,000 units in 10 different straits, and so we should be better able to use that as a strength for treating each of these circumstances more on a one-to-one, on a case-by-case basis. But as Kurt says, treating cases with the same circumstances the same way.
Yeah, definitely. Thank you, Mark. So I know we're running out of time, so I wanted to get through some of these other issues fairly quickly so we have some time to answer the questions. So let's talk about screening. We'll start with criminal record screening. In April 2016 of last year, HUD came out with guidance that emphasized the idea that African Americans and Hispanics are arrested and convicted at higher rates disproportionate to their share in the general population. So consequently, criminal records-based barriers to housing are likely to have a disproportionate impact on minority home seekers. So it's this idea of disparate impact on the protected classes. This guidance basically lays out the restrictions for owners who use criminal records or past criminal convictions to screen applicants in their properties. And the guidance is used by HUD and these local fair housing groups to determine whether you've committed a discriminatory act under the law. And I sort of emphasize the main points here. We did have an attorney review the guidance and come up with some best practices, because I know when the guidance first came out last year, you know, everyone in the industry was in an understandable uproar on what to do and all of these additional requirements. And so we came up with these do's and don'ts. I wanted to give you guys a couple key considerations here. You want to make sure that you have a written policy and that it's tailored to legitimate concerns. I know that last year, sort of around the time when the guidance came out, a group called the Lawyers Committee for Civil Rights Under Law, it's a DC-based national advocacy group, they were sending letters to NAA members telling them, we think your screening policies are violating the law. Can you send us your written policies and your resident data so we can determine if there's a violation? And of course, members said, absolutely not. And why would you do that? But of course, that's a scary proposition to get a letter like that. You don't know whether this advocacy group has any power or not, and you know what that could do to your business, of course. So we want to make sure you think of these as key takeaways. You should not deny solely on the basis of arrests or pending charges. And in the case of the Lawyers Committee letters, we had one NAA member say that they were targeted because they put their screening criteria on their website. And they thought they were doing applicants a favor by saying, this is our screening criteria. If you fall into any of these categories, you know, don't waste the application fee, don't bother applying. But really that set them up to be under scrutiny. And of course, like we've said this whole time, make sure you have a documented written policy, particularly for your screening criteria, but don't go and post that on your website. Make sure you have it at hand and that, you know, you're training your staff and your employees and applicants on what that is, but be careful on publicizing that information. Another issue that, another key takeaway we wanted to give you all is the criteria, along with that example, the criteria or the guidance, says you should not have categorical bans. And along with that, in that example, they were listing all the categorical bans where they said you need not apply. Again, make sure you're careful on how you're phrasing that and what you're doing in your screening criteria. And along with that, the guidance also says you must make an individualized assessment when you're looking at an applicant screening criteria. And I know this can be, you know, a bit burdensome and scary for some owners, but I know that Lauren and Mark and I had discussed, let's take, for example, if you had an applicant who was convicted of sexual assault 6 months ago, can you outright deny that application? And as part of the guidance, if you do have a screening policy, you would need to show that that policy serves a substantial, legitimate, non-discriminatory interest for that policy to hold up in court. So, you know, you would have a strong case for prohibiting sex offenders from your properties and showing that serves a substantial, legitimate, non-discriminatory interest. But you may also want to consider implementing an appeals process to give you additional cover. And that also would help, you know, show that you did go through that case-by-case analysis. And given the example of a sex crime, if someone did have a crime that was listed on a sex offender registry and you gave them the opportunity for an appeal, they might say, probably rarely, but they might say, I was convicted of public urination in college. That's how I ended up on the registry. And they might be able to explain that away. And then you have the opportunity to look at those extenuating circumstances and do that case-by-case analysis on the back end. And Kirk, did you have thoughts on this one as well?
Well, the first thing I want everybody to remember is that the HUD guidance is just that. It's a guidance. It's not law. It's not rules. It's nothing else. And we don't need to overreact too much to it. I think some of the things that came out of the guidance are things that we all would like to, that are logical, that there are things that some, not all felons are the same, and so we needed to have a reevaluation of our processes in the industry to make sure that we were being careful about the people that we take in, but not being overbroad on it. You have to remember that this is, again, it's a guidance, and so we're trying not to be the test case in any of this, but so far we haven't really seen any significant movement on this other than a few threats and some testing that's being done. And I think the key really is to make sure you have a good policy in place so that if you're ever asked about your policy, that you can present what your policy is and that the policy is consistent with the things that you've seen on the screen here, the do's and do nots. But likely we're going to deny the same people that we denied before the guidance came out, with a few exceptions. I always use the Martha Stewart issue that, she's a convicted felon, and yet most of us would probably accept her because the crime she committed was different than a violent crime against an individual. And to the extent that the no felony policy excludes people like that, it probably wasn't a good policy within the industry. That being said, most of us are still going to deny the same types of people that we denied before, and make sure your policy is in such a way that your evaluation is taking into account the reasons why you would want to deny somebody in those circumstances. And then I think the key is really this appeal process, which allows somebody who's been denied because of their criminal activity to be able to come in and give you additional circumstances on why maybe they should be reconsidered on that. I think that helps mitigate significantly, and also is consistent with what the Supreme Court decision on disparate impact really indicated. It's one of the keys to making sure that we're protecting ourselves from having liability under this area.
Thank you, Kirk. Mark, did you have any thoughts?
Yes, I might be helpful if I share my company's, how we view the criminal, and please feel free to jump in if you wish and say that's not the right way to do it, but I'll share what we do, and this is not what NAA recommends in any way. We look at no felonies under 7 years and no sexual assault. However, that is appealable to our general operations manager at any time. So we kind of use that under 7 years, a felon convicted of a felony is probably going to fail unless it gets appealed. And the sexual assault is probably going to fail unless it gets appealed. After that, many things are maybes and can be pushed up from the manager to the general operations manager for review at any time. So I think most of the time if there are things like felons with deferred adjudication or felons over 7 years that have bad violence on their records, or felons over 7 years that have a lot of recent misdemeanors. Those things probably get passed up to our general manager for a review before they're either accepted or denied. But the first two, again, no felonies under 7 years and no sexual assault are usually fails, but because they're so heavily weighted. But if that's on their record, it certainly is appealable, and that's how we treat it. We are looking at changing to 5 years instead of the 7 years because we hear that if somebody gets over the 5-year mark or the 7-year mark and they haven't done anything, and that's 5 or 7 years after they've been out of prison or after their probationary period has expired, then that's something Kirk talked to me a little bit about in a prior phone call as well. then the chances of them recommitting are not that great. So we're looking at changing from the 7-year mark to the 5-year mark. The other thing I would add with regards all of what we're discussing today to my fellow IROs, who generally we are very entrepreneurial, is with any of these decisions, whether it's the emotional support animals or the disparate impact or the criminal screening, when you make a decision on each of these situations, write down the decision, organize your decisions, and develop a little decision-making model for yourself, and then 6 to 9 months later revisit that decision to see if it worked out for you, so that you learn as you go along, and it also helps you document what you did and why you did it. And that would be my advice on this overall way of looking at this. And that's what I have to say on this. Thanks, Nicole.
Thank you, Mark. So I know we want to get to questions really quickly. We wanted to talk about an emerging issue that's been in the news a lot lately. It's eviction screening. We're seeing sort of a change in the dialogue here. While evictions has long been an issue or concern for advocates and policymakers, there seems to be a shift in the dialogue where now the evictions issue is a crisis. And we're seeing that Matthew Desmond, his book, Evicted, Poverty and Profit in the American City, has really resonated with advocates and policymakers alike. And I think what's different here, he's a Harvard educated academic. He won a MacArthur Genius Grant Award, and this particular book has received a lot of recognition. I think what's different than what his peers have done is he did not write a book purely on his academic research. He added in these, kind of pull at the heartstrings stories of his subjects. So he really went into detail in sort of the plight of these, of his low-income apartment resident peers who he was living amongst in I believe it was a trailer park in Milwaukee and maybe a smaller apartment building in a low-income area in Milwaukee. He really, it is a combination of his academic research on evictions and the plight of these people's stories. So it really is resonating with people all around the country, policymakers included, and we're seeing changes being considered at the federal, state, and local level, and particularly in the courts. And I know, Kirk, did you want to talk a little bit about that before we move on to questions? What happened in Washington?
Yeah, I'm happy to talk about it. I would encourage everybody to read the book because I think it's a good read for everybody to understand what it is. And I think once you've read the book, you realize that it is really they're trying to extrapolate an experience in one city to every city in the United States. And I don't think it translates as well. That being said, there are ways to protect yourself in eviction screenings as well, and to make sure that you're being careful about it. And that is to actually look for not only for the eviction, but to be doing the follow-up with the landlords. It's a lot easier to deny somebody on the basis of a bad reference from a landlord and then not having to rely upon the eviction record that may or may not be complete because you're just getting that information from your screening company. And so you need to be careful about how you handle eviction screenings. We've seen cases pop up. None of them have really gotten very far at this point, and most of them are either settled or have gone a different direction. But it is an area that we're seeing more and more, again, dealing with this disparate impact, because in most of the places that these are popping up, it's because there is an argument that more minorities are being evicted than people of the non-minorities. And as a result of that, then using eviction screening creates this disparate impact. And so you want to be careful when you're looking at this to make sure that if you're using eviction screening, that you're getting good information, that it's a legitimate reason why you need to deny them on that. And again, we look at timing of the eviction, how long ago did it occur, and I think following up on it with the same issues that we talk about criminal screening, that is an appeals process, and trying to verify the reasons for the evictions and seeing whether these people are good or bad tenants potentially are things that will help you in avoiding potential fair housing problems in eviction screening.
Thank you, Kirk. Mark, did you have any thoughts?
No, it is, Kirk said it all. I have nothing to add to that. Thank you.
Okay, thanks, Mark. All right, well, couple final notes. All of the resources that we talked about today, they're all listed in the PowerPoint, and we're going to send this PowerPoint out to everyone so that you have all the do's and don'ts and all of the resources that you have available with a deeper dive on this information as well. And we had a new white paper come out fairly recently that outlines some of HUD's guidance on some of these other issues that may or may not come up in your day-to-day. And just one more final note, if you have any specific questions on what we went through today, other than the advice of the people on the panel, we definitely recommend that you seek legal advice from an attorney in your area with fair housing expertise, because they really know. They've probably more likely than not already worked with the local fair housing group, know what you're up against, and can advise you accordingly. And in addition to that, I would also suggest build a relationship with your local rep, your local fair housing organization, or your HUD regional office, and do it before do it when it's a question, a compliance question, before it becomes a response to an actual discrimination complaint. Because then at that point you're involved in in the thick of it in a conciliation agreement, and that's not necessarily the time. It's more a time to figure out lessons learned, but do it before it gets to that point. And then once you have a contact at that local agency, should you have any questions, you can go back to them and ask, before it becomes a problem. And with that said, so we'll move on to Q&A, and I'm sorry we're keeping people past the time, but we did get a lot of great questions. So we'll start with the first one here. It is there any limitation on what type of animal is an emotional support animal? And Kirk, do you maybe want to go through, let's say you get a snake or a rooster or something, what do you do then?
Well, there isn't really any limitation, unfortunately. Sometimes we try and look to the local laws of the city or county that you're in to see if they have any restrictions, and often they will. They'll have restrictions on farm animals and things like that. And that would give you an opportunity to say, well, we can't accept this because it violates the local ordinances. We see those local ordinances quickly falling, or at least having exceptions made, because the city and county can't violate the fair housing rules any more than we can. And so often laws like that are violative of the Fair Housing Act unless they can justify it. But that gives you the first step in doing it. If there's a restriction on farm animals, exotic animals, and things like that, to require them to get some variance from the city or county. The other is, obviously, if it's too unusual of an animal, is to go a little bit further with the medical provider or whoever provides the documentation to you to verify that there is a legitimate nexus between the disability and the need for that animal. Often we find that question, we find often a lot of the medical providers don't even know what animal they're asking for. And when they're informed of the type of animal, it changes their opinion of whether that person should have the animal or not. I'll tell you a quick little story here. I know we're past time, but we had a lady that in a senior housing community that came in and requested that she be allowed to keep 2 chickens as her emotional support animals. And of course, we questioned whether that was legitimate enough. We contacted the doctor, and the doctor had signed the forms but didn't know it was chickens that she was asking for. And he said, no, they're not. It's not chickens I was anticipating, and they won't help her in her disability, and so I can't give that verification. And so we were able to not get the chickens in there. The side note is, it was when we denied the chickens, she had to remove the chickens from the premises. She gave them to a friend of hers, and 3 weeks later she came into the office crying and screaming that her friend had eaten her emotional support chickens. And so often that other things happen to help resolve the problems. But you need to be careful when it's an unusual emotional support animal and make sure there's a nexus between the two.
Thanks, Kirk. So we have several emotional support animal questions. We have another person, Brian, who asked, can you ask for re-verification of the need for the ESA upon renewal? Any thoughts on that?
We generally don't recommend you do that. If you followed the process well the first time, then it probably is something that should remain. In our discussions with HUD on this issue, on the forms that are in the toolkit, we actually have a date that says, is there a date at which this prescription expires? If they put a date on the prescription expiring, then yes, you could go back and say, well, this is an expired one and we need you to get a new one. If they say indefinite or unknown or something like that, then likely you can't go any further unless you'd have some cause to believe that there's been a change in circumstance to do that. So once you've done a good qualification of somebody, because remember, what we're qualifying is the individual, not the animal. And so if the individual qualifies as handicapped to the extent that they are entitled to an emotional support animal or a service animal or some type of assistance animal, then generally that is a long-term disability and we would not need to re-qualify the person for that animal. If they get a new animal, we may want to relook at it at that point.
Thank you, Kirk. We'll end on one final question. I think this is an interesting one. I let my sister, who has an emotional support animal and very bad credit, live in my 5-unit building, which I own, for free, no lease, no legal agreement. Do I need to vet her support animal credit history as vigorously as I would a paying tenant, or can I treat family or non-paying tenants differently in the same building?
I think the key to this is consistency, and whether if they're living in the community, then they need to be vetted the same way regardless of their situation. Anytime you make exceptions to your rules, you open yourself up for potential fair housing issues. And so because you know her, you may have more information already that you don't need to go much further. Remember, we have this readily apparent standard, and that includes readily apparent because you already have knowledge of things. But when you're going to allow somebody in with a less stringent vetting than you would somebody else, you need to document in the file why you have a less stringent vetting and make sure that you have the same type of information on that person that you would require off of anybody else in order to vet them. And so if it's your sister and you know that she has emotional problems and you know that she has a need for the dog, you may still want to have her make the request. You may want to still identify the animal, but the doctor's notation on that may be because you have sufficient information in your history with that person that you can document in the file why you made an exception to your rules to allow her to have an emotional support animal.
Great. Thank you, Kirk. And thank you to all our speakers today. I hope that we provided you with a lot of good information. Wanted to go to the next slide so you have all of our contact info should you need it. And thanks again to all of you for participating and sticking with us past the time. Sorry about that. As a reminder, this webinar was recorded and it will be available soon at the AE Exchange site on the NAA website. You'll just need to select the independent rental owner category to find the recording. After this call, we're going to send out a survey, email that to you, and we ask for you to complete it and help us determine next topics for the future for our IRO webinar series. So thank you again and take care.
Thanks, bye.